Okay, hello everyone. Let me make sure I'm recording this before I go on. Okay, it is. Okay, hello everyone. Good morning, well, good afternoon. My name's Karen Skio, and this is our second quarter policy guidance webinar that we'll be going over today. So before we get started, there's a few things that I wanted to mention. Um, a lot of people ask, will the webinar be recorded? It will be recorded. So if anybody has an objection to that, you can go ahead and put something in the chat and we will not record. Also, a copy of the recorded webinar will be available in about a week after the presentation. There is a link where you can find this at the end of the presentation. A copy of this PowerPoint, I was supposed to email this to you guys prior to the webinar. However, I did not. So immediately after the webinar, I'll send you a PDF of the slides that we cover today. I tried to put it in the chat and unfortunately I wasn't able to do that. And my contact information is at the bottom. If you're having trouble with the slides or deck or want to see follow-up questions, you can email me at that email address. On the agenda for today, we have 4 letters that we'll be covering: ACL 2439, ACL 2503, ACL 2508, and ACL 2520. We're going to go ahead and begin today with our ACL 2439. This is case transfers to Tribal Title 4E. Agencies presented by Angie and Kim Wrigley. And go ahead whenever you're ready, and we'll go ahead and get started. Okay, I don't see, bear with me. Sorry, everyone. I'm not sure that we have our presenter on, so just bear with me and we'll get started momentarily. Let's go ahead. We'll move over to, we may do this a little bit out of order since I don't see Angie or, oops. All right, let's go ahead. I'll send a message out to Angie and Kim about their presentation, but let's go ahead and move forward. We'll just go out of order and return back to ACL 2503. So we'll go ahead and start with Ian. Let me go to your section, Ian. So just bear with me. I'll go through some of these slides and get to your letter, and we'll come back to this letter in just a moment. So let's see. Pardon me, guys. Sorry about that. All right, here we go. So we're going to be doing ACL 2503. This is the Indian Child Welfare Act, Voluntary Proceedings and Involuntary Proceedings. And this is going to be presented by Ian Clark. So Ian, whenever you're ready, I'll send it over to you.
Sounds great. Hi, everyone. Thanks for tuning in today. My name is Ian Clark, and I am the unit manager of the Family Intake and Engagement Unit of the Children and Family Services Division here at CDSS. So this recorded webinar will discuss the 4th in a series of 6 ACLs that are being published about the Indian Child Welfare Act and its requirements. In particular, this letter that we're talking about today provides guidance. Sure, I'll try to lean closer. This letter provides guidance to county child welfare services agencies and county probation departments related to the amendments to Welfare and Institutions Codes passed under Assembly Bill 3176 and AB 2944, just to conform to the state law and its requirements to the ICWA and provide a higher standard of protection to the rights of parents or Indian custodians of Indian children than the rights provided under the ICWA pursuant to federal statute. So again, this letter focuses on the voluntary and involuntary proceedings requirement related to the ICWA. But this webinar definitely doesn't take the place of reading the actual ACL. I'd really recommend reading the ACL. It's just a high-level overview of some of the major points made in the ACL, but please refer to the ACL for detailed information. And I'm happy to answer any questions that you may have. We will have a Q&A portion at the end, as Karen mentioned. And I believe there are some slides in here throughout the presentation that provide some opportunity for us to be able to do that throughout. But also feel free to enter questions into the chat or raise your hand if that option is available in this particular recorded webinar. Whatever you're comfortable with, just let me know if you have any questions. Next slide, please.
Okay, and there was a request in the chat, Ian, if you could just speak a little bit louder, that'd be great. Thank you.
Oh, yeah. All right, so I don't know this. It looks like, no, this is right. Okay. So again, this series of ACLs is a follow-up to ACL 2038, which indicated that CDSS would release further policy and best practice guidance to provide support for implementing the changes to the Welfare Institutions Code made to conform with the 2016 amendments to the Bureau of Indian Affairs regulations. So yeah, the ICWA establishes minimum standards for state court proceedings, including dependency, delinquency, probate guardianship, and family court proceedings involving Indian children. However, states and counties have inconsistently applied the ICWA. And so California has since incorporated and expanded on the minimum federal ICWA standards adopted and clarified by the Bureau of Indian Affairs into statute with the passage of AB 3176 and 2944. This was really just to create a statewide standard for the ICWA, and California statute dictates that county placing agencies have a responsibility to meet ICWA standards in order to ensure the safety of California's Indian children and help those children remain safely in or return to their homes whenever possible. Next slide. All right, so ACLs have already been released that thoroughly address the inquiry and active efforts requirements for ICWA investigations and proceedings. I think someone's having difficulty seeing the presentation, Karen. Just wanted to make sure.
Yeah, it might be other people are reporting that they can see. So yeah, sorry about that, Joanne. If you can't go ahead and put your email in the chat and I'll send you a slide deck via email.
Sorry. So yeah, active efforts. We've already released an ACL for those amendments to the WIC code that 3176 implemented. Active efforts, again, are a higher standard than reasonable efforts. They are affirmative, active, thorough, and timely efforts intended to maintain or reunite an Indian child with their family. And they should be integrated into the child workers practice and the social workers practice and the probation officers practice. And they need to engage the Indian child and the Indian child's parents, guardians, custodians, extended family members, and of course, the Indian child's tribe. These efforts include identifying appropriate services centered around helping the family to overcome barriers, including actively assisting them in obtaining services. The active efforts requirement applies in any proceeding involving an Indian child. I know we've already presented on active efforts, but this is one of the primary points when it comes to proceedings. The active efforts requirement still applies in any proceeding involving an Indian child, whether it's voluntary or involuntary. The court must conclude prior to ordering an involuntary foster care placement or termination of parental rights that active efforts have been made to prevent the breakup of the Indian family and that those efforts have been unsuccessful. For active efforts to be successful, county agencies must develop close relationships with tribal social services agencies, cultural groups, individuals for the tribes within their jurisdiction and without. It's all about developing those really strong working relationships and understandings about how best to communicate. Next slide. So when it comes to voluntary proceedings, in California, the application of the ICWA is inclusive of voluntary proceedings. So a voluntary proceeding includes any proceeding for foster care, pre-adoptive, or adoptive placement that either parent, both parents, or the Indian custodian has of their free will without a threat of a removal by the state agency, consented to for the Indian child, or proceeding for voluntary termination of parental rights. Want to really emphasize without a threat of removal by a state agency, because that's something that a lot of county state agencies are working on. And that it is such an important point. It's not just ensuring that they agree to the services, but that those services aren't agreed to under duress. In voluntary proceedings with county agencies, the county agency remains involved, but the parents or Indian custodians retain the right to revoke the county's custody of the child at any time upon demand. And when we say upon demand, when statute refers to upon demand, it means that a parent or Indian custodian guardian can regain physical custody of that Indian child during a voluntary proceeding upon verbal request without any delay, formality, contingency. The child has to go home. As ACL 2038 outlines, voluntary proceedings have to be presented in and overseen by the court still, even though they are a voluntary proceeding. And consent for the proceedings must be provided by the parents, guardians, or Indian custodians and recorded before a judge. That judge will also need to certify that the terms and consequences of engaging in a voluntary proceeding were fully explained and understood by the family. Next slide. So voluntary proceedings are not technically considered Indian child custody proceedings, as the parent still retains the right to have their child returned upon demand, right? Even though they aren't considered Indian child custody proceedings, as I mentioned before, all provisions of the ICWA still apply to voluntary proceedings. Another important factor to consider is that even though parents may voluntarily agree to court oversight in proceedings, the child may not. The Indian child may not. It is the responsibility of the social worker to elevate the voice of the Indian child in the proceedings and to try to address any objections or reservations a child has around proceedings, placements, case plan, anything pertaining to what would be included in a voluntary case. The social worker will have to make efforts to ensure the child's voice is heard and that efforts are made to address any reasonable objections that the child might have to voluntary proceedings, placement, and the case plan. The social worker will also speak with the child in addition to their parents, the guardians, Indian custodians, and the tribe to also determine their willingness to engage in voluntary proceedings and collaborate with them in mitigating any potential harm or adverse impacts on the child that voluntary proceeding might have. So voluntary proceedings may also become involuntary too, if circumstances become unsafe for the Indian child. For example, if a parent enters into a voluntary custody arrangement with a child welfare agency, and at the end of the voluntary placement period, the child welfare agency believes that the safety threats have not been mitigated, the agency would need to file a petition for removal with the court if exigent circumstances do not exist, if that child is not in immediate danger. And only one parent needs to consent to a voluntary proceeding. I know that can be somewhat confusing because what about the other parent? If one parent consents to the placement of an Indian child and the other does not, the proceeding is treated as an involuntary proceeding as it relates to the non-consenting parent. Next slide. All right, I just wanted to leave the space for any questions that have come up from the previous slides. If anyone wants to, if you can they unmute, Karen?
I'm sorry, what's that?
So like in these Q&A like sections, can they
Oh,
unmute and
oh.
ask her?
Yeah, you can put your question in the chat.
Oh,
Yeah.
okay. Yeah, just please put your question in the chat, and I think Karen will read them out. Let's provide maybe a few seconds if folks are writing their questions.
I don't notice anything in the chat right now.
Okay. Maybe while we're going through the next slide, if questions do pop through, I can answer them. So yeah, next slide.
All right. There we go.
Thank you. So involuntary proceedings, in this context, an involuntary proceeding is an Indian child proceeding, wherein the parents, guardians, or Indian custodians cannot have the child returned to them upon demand, or where the parent only consents to foster care, pre-adoptive, or adoptive placement under threat of removal, right? So anytime there's a threat of removal, that constitutes as an involuntary action, right? I believe we got a question though. Let's see. Okay, were there any major changes identified that are completely new from previous instructions? Yes, so what we're outlining was fairly new at the time that it was the change. Those were the changes that were made to the WIC. Do you have any area that you're looking at specifically, Pablo? I know this is not the greatest. Okay. So yeah, there were changes. I'm primarily going over the changes that 3176, 2944 made to our welfare and institutions code. It's been a while since those particular bills have passed. And so this is bringing whatever changes those bills made to statute to the attention of counties, just to ensure that they are understanding the law and that they are following the law as it relates to ICWA and in particular for this letter for proceedings. Good question. So in this context, again, an involuntary proceeding is where the child cannot be returned upon demand or where the parent only consents under duress, under a threat of removal. And there are 4 outcomes of involuntary proceedings. Those include that the child returns home, that there is an emergency involuntary removal, that an involuntary foster care placement occurs, or at the end of the case, involuntary termination of parental rights. There are some caveats, and I'm going to be going over each of these, besides the child returning home, because you don't need much direction for that. But I will be going over emergency involuntary removals, foster care placement, and involuntary termination of parental rights. So next slide, please. So in this context, in particular, as it relates to emergency involuntary removals, removal is different than formal detention by the court. So if a worker sees a child that's in immediate danger, sees an Indian child that's in immediate danger of imminent physical damage or harm, and these safety threats cannot be remedied with the parent and the support of the tribe, despite active efforts to keep the family together, then the child would need to be removed. If an Indian child is removed, the social worker has to report on these factors. So why the child was removed, if there's a need for continued detention, what services were referred to, and how active efforts were made to prevent removal. The social worker must also report whether there are any relatives or extended family members who are willing to take temporary physical custody of the child. Of course, these decisions should be made jointly with the child's tribe or tribal representative every time, and the emergency placement must comply with the tribe's preferences unless the court finds good cause to not follow the placement preferences. Next slide, please. So per WIC 319, the social workers report must also include the following. So it's the statement of the risk of imminent physical damage or harm, and that placement is necessary to prevent that harm or damage. The steps taken to notice the parents, the guardians, or the Indian custodians, as well as the tribe when there's reason to know the child is an Indian child about the hearing. The residence or domicile of the Indian child, and if they are believed to be on a reservation or Alaska Native village, and the name of the tribe affiliated with that reservation or village, not just that if they are believed to be on a reservation or village, but the tribal affiliation, as well as the tribal affiliation of the child and the parent, guardians, or Indian custodians. The social workers report also has to include a detailed account of circumstances leading to taking the Indian child into temporary custody. And if the child is believed to reside on a reservation in which the tribe exercises exclusive jurisdiction over child custody matters, a statement of efforts to contact the tribe and transfer the child to that tribe's jurisdiction. There must also be a statement of efforts taken to assist the parents, guardians, Indian custodians, and the tribes so the Indian child may be safely returned. And then lastly, steps taken to collaborate or consult with the tribe and outcomes of this collaboration and consultation. So how does the sovereignty status of tribes play into involuntary acts? So Jane Middleton, it definitely plays into involuntary proceedings. It depends, kind of related back to whether the tribe exercises exclusive jurisdiction over child custody matters. And then also tribes need to be part of decisions to remove a child if there are safety issues. They should be part of the like other assessment, structured decision-making assessments. They should be part of CFT. They should be part of that any decisions that are made when it comes to involuntary proceedings for an Indian child. So I don't know. Does that, let me know, Jane, if that answers your question, or if I need to kind of explicate a little bit more. Next slide. I think it's a blank slide. Oh, no. Okay. Involuntary proceedings, emergency involuntary removals, continuation from the previous slide. Emergency removal of an Indian child cannot last longer than 30 days unless the court makes some determinations. Those determinations are that returning the Indian child to the parent, guardians, or Indian custodian would result in imminent physical damage or harm to the child, or the court has been unable to transfer the proceedings to a tribal jurisdiction, or it has not been possible to have a hearing that complies with substantive requirements of the ICWA. If there's any party that maintains that there is new information that indicates that the emergency situation that led to removal has ended, any party may request an ex parte hearing by submitting an ICWA 070 in that county jurisdiction. And the court has to determine if the emergency placement is no longer necessary to prevent physical injury or harm. And if the court determines that it's no longer necessary, then the court has to order that the child return to the physical custody of their parent, guardian, or Indian custodian. Okay, next slide, please. Any questions at this time? All right, doesn't seem like it, but if they pop up, then let's keep going, and we'll answer them as they come. So next slide, please. All right. So if there is an emergency removal of an Indian child from their parent, guardian, or Indian custodian, it cannot last more than 30 days unless the court makes those specific orders, right? But another, in particular, around involuntary foster care placement, I think, didn't we already? Yeah, we already went over the next slide, please. I believe we already discussed these. Next slide, please. Okay, there we go. So yes, involuntary foster care placements. Yeah, another kind of involuntary proceeding centers around the involuntary foster care placement of an Indian child. I wanted to list the statute as it's written with the caveat of recognizing that the statute does not explicitly identify Indian children and the special status that they hold. In the listed statutes, Indian children are included under the blanket term minor, though I will be referring to the minor as an Indian child for the purposes of this ACL and this presentation. In order for the court to make an order for foster care for an Indian child, the court must find that there was clear and convincing evidence of any of the following. As we've already discussed, substantial danger to physical safety, health, protection, or physical or emotional well-being of an Indian child, and there's no reasonable means to protect their physical health without removal. As it's outlined in WIC 366.26, the parent, guardian, or Indian custodian, if they're unwilling to have physical custody of an Indian child, of their Indian child, and they have been notified of the possibility of their child being declared free of their custody and control, and then that Indian child remains out of their custody for a period of time, then that's one of the ways that the court, that's one of the circumstances that can exist that the court has to consider. Another thing that courts need to consider is whether the Indian child is suffering from severe emotional damage and there are no reasonable means to protect their emotional health without removal. Next slide, please. This is a continuation of the list from the previous slide. So the court must find that there was clear and convincing evidence that the Indian child has been sexually abused or is at substantial risk of sexual abuse and no reasonable means to protect the Indian child without removal, or the Indian child does not wish to return to their parent, guardian, or Indian custodian, or the Indian child has been left without provision for their support, or their parent, guardian, or Indian custodian has been incarcerated or institutionalized, that they cannot care or arrange care for their child, or the whereabouts of that parent, guardian, or Indian custodian are unknown, and efforts to locate them have been unsuccessful. Not only must the court find that clear and convincing evidence of any of these factors exist, but this evidence must also be supported by a qualified expert witness testimony in order for foster care placement to be ordered for an Indian child. So qualified expert witness testimony is required. Little side note, we are going to be posting another letter in this series for qualified expert witnesses, pertaining to qualified expert witnesses, and how counties need to include them in their process and their cases. Next slide. So the last kind of involuntary proceeding I'll be addressing today, and that's listed in the ACL, relates to the involuntary termination of parental rights. So this would include any action involving an Indian child that would result in the termination of the parent-child relationship. Proof beyond a reasonable doubt is the evidentiary standard required for the court to order any termination of parental rights for an Indian child. This is also, that evidence needs to also, again, be supported by a qualified expert witness testimony. Statute always talks about how the court and the county social worker have to consider the prevailing social and cultural standards of the Indian child's tribe. But the social worker is responsible for communicating with the Indian child, their parents, their family members, their extended family members, and tribal representatives to obtain information about these standards and just consult the research and the information they're provided, really truly understand, gain an understanding of what these standards are to be able to inform their active efforts and ensure that these standards are being met, not just for term related to involuntary termination, but pertaining to any case for any Indian child. Next slide. Is QEW report or testimony needed when a child does not meet the blood levels to be an enrolled member of the tribe? As it relates to, let's say one of the parents is an enrolled member, if the child is a member or eligible for membership and they meet the requirements for to be an Indian child as it relates under the ICWA, then QEW report or testimony would be required. So I know each individual tribe has specific membership qualifications, eligibility criteria. It's really up to the tribe to say whether that child is a member or eligible for membership. And the statute falls back on that. Like if the tribe determines that, then it is required. All right, any other questions? All right, well, I provided my unit's contact information in case if you didn't want to ask here in this setting, any questions that you had, or if you think of any questions after the fact. I believe Denise Wynn, right? Does conservatorship include conservatorship under the WIC as well as probate code? That is, I am not familiar so much with the WIC code as it relates to conservatorship. That is a question that I will have to go back and research and connect with whichever unit I think oversees conservatorships. But I can definitely connect you with someone who will be able to get you an answer to that question. All right, and then I provided one resource down here at the bottom, continues to be a really good resource for counties, is the Judicial Council of California issued an ICWA informational sheet. It's, in my opinion, really helpful. I found it helpful as a county worker. It does go over some parts of what we went over today. And it's something that I believe is also referred to in some of the letters that we put out as well. All right, and I believe that's it.
Okay, thank you very much, Ian, for that. All right, so we're going to go ahead and navigate back a little bit, and we have the letter, the ACL, excuse me, 2439, that's so small, transfer of tribal youth from counties. And this is going to be presented by Kim Wrigley. So I'll go ahead and once again, just talk about what we're going to be talking about. This is case transfers to tribal Title 40 agencies, and this is going to be presented by Kim. So Kim, whenever you're ready, you can go ahead and begin.
Great. Thank you, everybody. Thanks for having us. As you can see with the ACL number, this was posted, probably close to a year ago. So it's a one of our older ACLs, and I apologize it's taken so long to present this. But can we go to the next slide? So the purpose of this all-county letter was to provide an updated overview of all of the legal requirements, procedures, and the best practices for transferring cases from county jurisdiction to a tribal Title IV agency or to an Indian tribe that has a Title IV agreement with the state. Currently, we do have 2 tribes, Yurok and Karuk, who do have that Title IV agreement with us. And it was really, this ACO was also written to because we understood that there had been a lot of outdated information from All County Letter 1415. So we really wanted to provide better updated information and clarification to that previous guidance. Next slide. So just to give people a little bit of background information. Federal law does allow agreements to occur between states and federally recognized tribes regarding child welfare cases and Title IV funding. This was also further expanded for tribes who had entered into a direct Title IV agreement with the federal government. So there's 2 types of Title IV agreements that tribes can enter into, one directly with the federal government and one with the state. And some of the authority under that is in WIC 10553.1. Next slide. So to go a little bit more into detail about some of these federal regulations, they do mandate the procedures for transferring Title IV cases in such a way that it does not affect a child's eligibility for benefits. It is crucial that when cases are being transferred to the tribe, that that protection, that transfer of that child's eligibility for those benefits maintains. So when the transfer is occurring, it does need to include all of the information about eligibility determinations, as well as the essential information and documentation for them to maintain their continuity, sorry, I can't say the word today, for Title IV and for Medicaid, Medi-Cal here in California. These also do not affect a tribe's ICWA right to seek jurisdiction over the Indian children's cases. Next slide. So for tribal transfers, some of the requirements, and again, there's a lot of detailed information in this ACL. So we're just giving you the briefest of brief overview. So please, if you're working on a transfer case, have that letter open and look at all of the steps involved. But tribes do have the right to jurisdiction and case file access. The complete case file, the children's case file in whole must be transferred to the tribe upon once the court order has been ordering the transfer has occurred. However, Medi-Cal must remain active under the county's responsibility. There are issues. This has to occur because the aid codes cannot occur under the tribe. So Medi-Cal's, the aid code must stay with the county, and the county would still remain responsibility for that Medi-Cal responsibility there. For out-of-state transfers, the county, in terms of if for Medicaid, they should contact their DHCS foster care program to ensure the smooth transfer of Medi-Cal and Medicaid in those situations. Next slide. So some other things involved in the tribal transfer process. As I said, the case file must be, one of the things that can occur is the tribe may notify you and make an official request for the initial transfer. So at that point in time, the case file should be transmitted. It does not need to wait until the court order. It should not be delayed because of a court order. Counties, if they have not completed the Title IV eligibility determination at that point in time, must do so within 30 days of that request. And all essential documentation must be provided to the tribe to ensure uninterrupted services at that time. And this is again related to a transfer request. This means that the transfer has not been completed through court order yet, but the process should begin at that point in time. Next slide. So some of the information that is mandatory and required for all transfer cases, these are some of the forms, FC2, 3, 3A, the SOC 158A. In situations where there may be an adoption assistance agreement or a kin gap agreement set up, some additional documents is applicable. And then, as I mentioned earlier, the eligibility determination needs to be expedited to prevent any delays for the transfer there. Next slide. Other required documentation for the transfer would include all of the court petitions, orders, reports, findings and orders, the placement history and care records, full payment history for this foster care episode, everything related to the foster care episode, case plan, health education, passports, anything related to federal benefit documentation such as SSI, child support, survivors benefits, all of that must be included in the transfer to the tribe. Next slide. Some practice considerations when they're doing the tribal transfers, and I would say it's almost more than a practice consideration, is to ensure a transfer goes through seamlessly. Collaboration between the county and tribe is essential. It cannot happen well with all the information provided without that communication, without that collaboration. It's really important for the counties to be sharing with the tribe all the information they have about the child's case plans, any health issues, any behavioral concerns. Everything should be communicated upfront and as expeditiously as possible. It's highly advised that joint visits actually occur between the county and the tribe with the family, with the child before the transfer completion. That would help with the communication, the collaboration, and for the family to understand what is happening and for them to have that warm handoff from the county to the tribal representative. So joint visits are very helpful to ensure this happens seamlessly and that no services to the child or the family are interrupted as a result of this transfer process. Next slide. Some placement specific documentation. I actually have a little bit of a edit to make on this slide. Under resource family homes, information about the RFA certificate that will typically be an RFA 05A or LIC 05A, or there could be equivalent form that should be provided. Under background check clearances, that what we mean by that is the dates that the background check clearances were completed, as well as some information about whether an exemption was needed or not. You do not provide the full background checks, the criminal offender record indexes. Those should never be transferred over. There's some strict penal codes that prevent the transfer of that information, but the dates of the background check should be included. That could be, if it's a county home, the RFA 02 is sufficient. It provides a lot of that information, as well as information about complaint investigation. So I just wanted to, I think we summarized that column a little too much. Just want to clarify that, again, that the full criminal record history information should not be included in the transfer, but the dates and whether an exemption was granted should be. If it's a tribally approved home, documents related to that approval, and again, a criminal history summary, not the full CORI, as I mentioned before. If there is a ICPC 100A or 100B, anything related to that, including forms, supervision reports, that kind of information would also need to be included. Next slide. As it relates to ICPC cases, tribes are exempt from ICPC agreements. They are sovereign government agencies that may cross from over state lines, so they are exempt from this process. So if a case is being transferred to a tribe and there's a current 100 ICPC agreement between California and the other state, the county must ensure that there is coordination with that tribe and receiving state, and they should be completing a 100B to terminate the agreement once the transfer has been completed. And that is, again, because tribes are exempt from ICPC. Next slide. So in conclusion, essentially, this again is a very high level over a very detailed process about the requirements, the steps, and some really practice considerations for counties if they have a case that's being transferred to the tribe. The important thing is, however the process occurs, it should include a seamless continuation of the services on the child and families end. They should see no difference in the support services, rates, any of that stuff. The only difference they should see is who may be coming to their home to visit and who they would contact for additional help and support. So again, the eligibility determination should be completed. Medicaid, Medi-Cal would remain with the county, but everything else would be a seamless transfer of services over to the tribe. So again, we really encourage you to read the ACL. We are happy to answer questions about it. Our contact information is listed there on the slide. And I think that concludes ACL 24-39.
Great. Thank you so much for hopping in. Really appreciate it.
No problem. Apologies for the miscommunication with the dates and times. Thank you.
No worries. No worries. All right. I will go ahead and advance to our next section. Let's see. Where are we? Let's see. We are going to go ahead and discuss ACL 2508, and this is being presented by Dana Androsky. This is going to talk about the implementation guidelines for forming a child and family team and providing child and family team meetings for children or youth in a family maintenance status. So whenever you're ready, go ahead, Dana.
Great. Thanks so much, Karen. Yeah, so that was a great introduction. So yes, All County Letter, or ACL 2508, was released on January 31st, 2025, and it provides information on the purpose, background, and guidance for the implementation of child and family teams, or CFTs, for youth who receive family maintenance or FM services. There was also a release webinar that was hosted on April 22nd, 2025. It is uploaded on YouTube. Let me go ahead and provide the links to both the ACL and the release webinar here. Yeah, so feel free to check out those links. Go ahead to the next slide, please. So to provide context for this ACL, I'll start by going over some background terms that you may or may not be familiar with. We'll start by defining the Child and Family Team, or CFT. So the CFT is a group of people that includes the child, youth, non-minor dependent, family members, and in the case of an Indian child, the tribal representative. The mechanism of the Child and Family Team is to inform the case plan and service planning collaboratively with the youth and family at the center so that different folks can offer their unique expertise to help provide the best array of services available to meet the youth and families' unique needs and strengths. Next, we'll talk about family maintenance. So when a youth and family receives family maintenance services, child welfare practitioners offer protection of the youth and provision of available services without removing the youth from the home, which is considered the least restrictive setting. As such, FM services must be an option to consider before making the decision to remove the youth from their families. Family maintenance services may be voluntary or they may be court ordered. Voluntary family maintenance or VFM services are the provision of non-court ordered, time-limited protective services to families whose children are in potential danger of abuse, neglect, or exploitation when the child can safely remain in the home and the family is willing to accept services and engage in corrective action. The agreement for voluntary services may be initiated by the county child welfare agency or by the court. However, the parent, guardian, or Indian custodian must not be coerced into agreeing to VFM services by threats of removing the children from the home if they do not engage in such services. Court FM services, on the other hand, are provided to families whose children have been adjudicated a dependent of the court, where the court has ordered the county child welfare department to supervise the family while the child remains in the home. In these cases, the court has made a determination that the children can remain safely in the home with the provision of services. Such services are appropriate when it is determined that the child does not need to be removed from the custody or of any parent or illegal guardian. And court FM services may also be provided when a child previously placed in out-of-home care is reunified with a parent or guardian or Indian custodian, and continued supervision is deemed necessary to help support the reunification. Oh, sorry. There were still, I'm back one slide. Sorry. Next, we'll be talking about the Integrated Practice Child and Adolescent Needs and Strengths tool. And please bear with me in case you're familiar with these or the IP CANs. So the IP CANs has traditionally been used for all child welfare cases since implementation began in 2018. So it has been a requirement in family maintenance cases when a youth remains with the family. However, child and family teams in family maintenance cases have been implemented at the county's discretion, depending on available funding and resources. But the IP CANs is a multi-purpose tool that the CFT uses to guide conversations, support decision-making, including level of care and service planning, and helps to monitor the service of outcomes. And finally, we'll discuss the BH Connect, or the Behavioral Health Community-Based Organized Networks of Equitable Care and Treatment, which was approved by the Department of Health and Human Services on December 16th, 2024. We won't go into detail about BH Connect today, but the BH Connect initiative is designed to increase access to and strengthen the continuum of community-based behavioral health services for Medi-Cal members living with significant behavioral health needs. And one of the populations of focus is children and youth involved in child welfare, and the BH Connect strengthens family-based services and supports for children and youth living with significant behavioral health care needs. This creates a need for increased care coordination, and the CDSS approved funding FMCFTs and FMCFT meetings to facilitate care coordination to support the implementation of BH Connect. And thank you, Daniel Kim kindly dropped a link for more information about BH Connect in the chat. And next slide, please, Karen. So a little bit about the background of child and family teams and family maintenance cases. They have long been recognized as Best practice, however, historically, they were not required or funded by CDSS. However, through survey, we've determined that 45 of 48 counties provide CFTs to FM cases. And some counties have reported positive outcomes in safety and permanency. We looked to make funds available for readiness and workforce training activities for FMCFTs in the 2023 to 24 fiscal year. So there's a CFL for that, CFL 232464, which I think I've got that one. Sorry, bear with me. So we released readiness funds through this fiscal letter. And funds became available for the meetings for these activities related to meetings beginning January 1st, 2025. And the ACL was also released at that time. So the CFL for the meeting activities is available in this document right here. Okay. Next slide, please. So what were some of the reasons that we decided to implement CFTs in FM cases? The implementation of CFTs for youth with FM status, including both voluntary and court-ordered family maintenance status, ensures equitable access to services and supports and palliative care for all youth involved in child welfare, regardless of where they are placed. So child welfare services are intended to prevent the unnecessary separation of children from their families by identifying family problems, assisting families in resolving their problems, and preventing the breakup of the family where the prevention of child removal is desirable and possible. And they are best provided in a framework that integrates service planning and delivery among multiple service systems, including the mental health system, using a team-based approach, such as a child and family team. Done to fidelity, CFTs and FM cases will help families keep youth at home, in school, and away from youth corrections involvement, and support the consistent integration of the IP cans into the CFT process. As I mentioned before, historically, the IP cans has been required for all child welfare cases. However, the CFTs have formally been required for placement. Youth and placement. So the alignment between systems is key to encourage family-centered understanding and healing, prevention of harm, safety and well-being, stability, and increased care coordination for all child welfare involved families. It also finally provides a venue for increased care coordination, as mentioned, necessary to implement the behavioral health community-based organized networks of equitable care and treatment, which is quite a mouthful, but BH Connect. And next slide, please. Next, we'll talk a bit about some of the high-level FM CFT guidelines that are in the letter. You can look for more information or feel free to ask questions in the chat, but the letter will have more details on these guidelines. They basically mirror placement CFT guidelines. So the first meeting is initiated by the case carrying social worker. So the timelines mirror those of placement CFTs and align with the IP cans and case plan requirements. So that means that the first CFT meeting takes place within 60 days of case opening, or within 30 days if a child is known or there is reason to know that a child is an Indian child. Subsequent CFT meetings take place at least every 6 months afterwards, or every 90 days if a youth receives intensive home-based services, IHBS, or intensive care coordination And then there's some more information. I think everyone has the slide deck on the CFLs if you're interested in that. Next slide, please. So again, we probably aren't going to get into too much detail about the actual contents, but we do hope you check out the ACL and the release webinar and hope that you get a lot of value out of it. But also included in ACL 2508 is information on how the FMCFT can be used to support safety planning, how it can be used to support transitions when a youth and family reunify. So as mentioned, sometimes court-ordered family maintenance services are provided to support families who have recently reunified and still need some support. Perhaps, like perhaps the family is experiencing challenges with housing or want ongoing behavioral health support. The letter can help provide guidance around that. It has information on how to make sure that there is ongoing, early and ongoing collaboration with the tribe in the FMCFT. As mentioned, the tribal representative is a required member of the CFT. So they should be included in the process, and there's more information about that in the letter, as well as the CFT Tribal Engagement Guide, if you're interested on that. There's also guidelines on sharing information and confidentiality within the FMCFT meeting, and facilitation guidance on how to best navigate challenges within the FMCFT meeting, say, or, to create better engagement with participants. So for that, you can also check out the CFT engagement guide, and I will drop the links in the chat to a few of the documents I mentioned momentarily. So really appreciate that. And I think we can go to the next slide as long as there are no questions. And thank you so much for joining to listen about this ACL. And please feel free to contact CWS coordination at dss.gov if you have inquiries about FMCFT guidance. Thanks.
Thank you so much, Dana. All right, we'll go ahead and move forward. If you think of any questions as we progress through the final remainder of the presentation, just go ahead and put them in the chat, and we can reach out to you separately via email. So we have our final presentation. This is ACL 2520. This is with regards to Adoption Assistance Program, Eligibility and Assembly Bill 2948. This is going to be presented by Marta Platt and Zachary Kim. So we'll go ahead and get started.
Hey everyone, my name is Zachary Kim. I am the AAP analyst, the Adoption Assistance Program analyst for the Department, California Department of Social Services. So ACL 2520 was released, I think, about 2 months ago, and it was in response to Assembly Bill 2948. And Assembly Bill 2948 made a change to one of the components of AAP eligibility. So ACL 2520 essentially breaks down what AB 2948 did in terms of changing AAP eligibility. And so as we go forward with this presentation and within the ACL, it basically talks about how AB 2948 changed AAP eligibility, specifically the first part of a 3-part special needs determination, which is a component of AAP eligibility. And then it talks more about the roles and responsibilities for the tribe, the responsible public agency, and the financially responsible county whenever it comes to establishing the AAP case prior to adoption finalization, and then everything else after the AAP case is established. Next slide, please. Okay, so just to give some like a brief explanation of what the three components of AAP eligibility are. The first one is the three-part special needs determination. All three parts need to be met. And so when eligibility is being determined, the financially responsible county and the responsible public agency, particularly the responsible public agency, will be determining the three-part special needs when determining AAP eligibility. The child also has to meet the citizenship requirement, so they have to be a U.S. citizen or a qualified alien. Just a reminder, in order to be a qualified alien, you would need to have LPR, legal permanency residency, or legal permanent residency status. And then the third component would be meeting an eligibility pathway. So for this population, it's limited to the applicable child Title IV-E federal pathway. So whenever a child is being determined eligible for AAP, they need to meet all three parts of AAP eligibility, all three components. And AB 2948 specifically amended one of our WIC codes that pertains to AAP, WIC section 16120A1. And basically, what it did was it allowed for an Indian child whose case was transferred from state court jurisdiction to tribal jurisdiction to meet the first part of a three-part special needs determination under AAP. So essentially, AB 2948 had to do with children who the county had dependency of of an Indian child. Their tribe stepped in. The jurisdiction was transferred to the tribe. The dependency ended within the county, and then essentially the tribe went through adoption for the child. And so, in order to make sure a child was eligible for AAP, AB 2948 essentially went into effect and allowed for children to be in those situations to be eligible for AAP. Next slide, please. Okay, so one of the main things with AAP, and it pertains to all cases, even with this population, the request for AAP benefits, the eligibility determination, but essentially negotiating the benefit and the execution of an AAP agreement and the non-recurring adoption expense agreement of up to $400 per child. All of that must be completed prior to the adoption finalizing. So counties just and tribes, please, please, please just make sure whenever there's a plan for adoption that you complete and establish the AAP process prior to the adoption finalizing. And then this next part, essentially the responsible public agency. So when I say responsible public agency, that would be the county adoption agency or the department. There's situations where counties will contract with our department in order to provide AAP services. So the responsible public agency will need to work with the tribe and the tribal prospective adoptive parent to ensure necessary documentation is complete and that necessary support is provided to ensure the AAP process is completed prior to tribal adoption finalization. So again, the main message with this slide is just make sure the adoption is not finalized prior to the AAP case being established. The AAP case must be established prior to adoption finalization. Next slide. Okay, so ACL 2520 also talks about the role of the federally recognized tribe. So again, at the time there's a plan for adoption and prior to the tribal adoption finalizing, the tribe will need to communicate to the county that previously had dependency jurisdiction of a child, that there is a plan for adoption. So whenever there's a plan for adoption, the tribe needs to communicate with the county who previously had dependency jurisdiction. And this will essentially initiate the AAP process. And then the tribe will need to assist the tribal adoptive parents with the request for AAP, so requesting AAP benefits, and then the submission of the AAP request packet to the responsible public agency, including all the supporting documentation to justify the request. So whenever there's a plan for adoption, obviously the tribe will communicate with the county, and then the tribe will need to help the parents request AAP, which will also include a request packet. And ACL 2520 breaks down what is included in the request packet, how to request AAP, and really how to work with the county in order to establish the AAP case and start the process. Next slide. So really, I mean, there's more information in ACL 2520, but the main things to really think about is the adoption cannot finalize until the AAP case is established. Really, tribes and counties will really need to work together in order to establish AAP for this population. The more they're able to collaborate and communicate, the better off everything will work out in terms of establishing the AAP case for a child prior to the adoption finalizing, and ensuring that these kiddos get AAP benefits. And throughout the ACL, we talk about the relationships that need to happen, the collaboration that needs to occur between the tribe and the county. We talk about really the role that the tribe will have in terms of supporting the parents and making the requests, and really initiating the process in order to request AAP and then to establish the AAP case. And then it talks about everything after the AAP case is established. Pretty much for any AAP case, parents need to continue to be in contact with their responsible public agency. This agency is the agency that works with the parents for the duration of an AAP case. Whenever there's a change to the AAP case, parents will need to communicate with the responsible public agency. Changes of address, when a child moves away to either another state or to another county, you need to transfer the medical benefits. Just really anything pertaining to the AAP case, that relationship will be between the parents and the responsible public agency. So the ACL elaborates more on that. But basically, the AAP case should be pretty much the same as any other AAP case. AB 2948 just expanded the eligibility for this population. And really ACL 2520 just breaks down the process, breaks down what the Assembly bill did, how AAP eligibility changed, and really what needs to happen in order to ensure that these kids are able to get AAP benefits. So if any of y'all are requesting training or webinars, we can provide them. Just reach out to us with our email address at aap@dss.ca.gov. If there's any questions, again, please email us. We can provide answers to any AAP questions or relating to ACL 2520 and AB 2948. So feel free to reach out to us. And tribes and counties, please, please, please work together. The more y'all collaborate and work together, the better off these kids will be, and we'll make sure they get AAP benefits. Thank you.
I see we have a question in the chat from Amy.
So can you expand on circumstances in which dependency would be terminated within county prior to the transfer to tribe and a plan for adoption? So Amy, are you talking about situations where the transfer of dependency wasn't transferred to the tribe, it just the dependency was terminated, and then the child went to the tribe for adoption? Yeah, so with AB 2948 and with this particular population, the situation in ACL 2520 talks about it more, but basically what would occur is a child, the county had dependency jurisdiction of a child, the tribe stepped in, they claimed jurisdiction of a child. In order to transfer the jurisdiction, the dependency would be terminated in the county, and then the transfer of jurisdiction would go to the tribe, and then the tribe would then have jurisdiction of a child, and then there would be a plan for adoption within the tribe. So we're just simply talking about situations where dependency was terminated within the county due to the transfer of jurisdiction to the tribe. Hopefully that helped out clarify the wording in the presentation. Okay.
All right, thank you so much. All right, well, that will conclude the webinar for this quarter. At the end of the slide, and I hope you all have received a copy of the presentation where you can access our CFSD letter page. You can also access the webinar page where we post all the recorded webinars. from this page. And then lastly, just thank you. We have our next policy guidance webinar scheduled for August 9th. And then also, just as a reminder, if you are not on our list to be notified of any upcoming webinars, there's a link where you can be added to our distribution list and be notified of anything coming up in the future. So thank you to all of our presenters. I know this information is really helpful for everybody, and we'll see you in August. And I hope everybody has a great rest of your day. Thank you so much.
Take care, everyone.
Oh, if it's a Saturday, we'll do the Thursday before. Thank you. Thank you, Melinda. We'll let you know.